Beers here, Beers and Gordon of Oviedo, your personal injury law firm. I'm here today to talk to you about what personal injury damages may be available to you from an automobile accident, and specifically what you may not know about the damages that are recoverable. Florida is a state that has a broad range of available remedies for types of injuries that can occur. Many people are under the misimpression or the misconception that Florida is a pain and suffering only jurisdiction. In other words, that all you can get is some amount of money that 6 jurors might determine would be fair for what you're suffering on a daily, weekly, monthly, or yearly basis. That is what is usually referred to by the insurance industry when they attack jury verdicts by your fellow citizens. The fact of the matter is that Florida has a very broad range of available damages if you can establish that you've received a permanent injury. A permanent injury does not require a permanent disability. All that is required under Florida law is that there has been some change in your physical being, which is of a permanent nature, which has impacted upon your ability to enjoy your life and go about your life and do your physical activities in the manner in which you were doing them prior to the crash. So, for example, you may receive mental anguish damages if it's particularly troubling to you from a rear-end collision. This is something we do see fairly frequently. Normally, several weeks after the crash, people have a tendency, victims, to forget about the fact that they were rear-ended. But there are some clients who, for years in the future, are really concerned when they're behind the wheel that they're going to get hit. They're constantly looking in the rear mirror. There are all kinds of behaviors that are consistent with a mental anguish claim. We have experience in developing these so that you can receive the compensation you're entitled to. So past pain and suffering, future pain and suffering, mental anguish, inconvenience is an element of damage under Florida's tort law arising from a personal injury claim, and loss of capacity to enjoy life. Very simply, have you received an injury that has impacted what you were doing prior to the crash for joy? So if you are the perfect example is if you're a pianist and you lost the use of your finger, even though you weren't a concert pianist and you weren't playing at Carnegie Hall, the fact of the matter is you got joy, and you gave joy to others in your family that you loved because of your talent. If you can't do that because you have an injury to your little pinky finger, then you've lost enjoyment of life. And that is an element of damage that is recoverable under Florida law. Many people do not understand that in a personal injury case, you're not limited to what doctors you can see. You have the right to a second opinion. You have the right to make sure you find a health practitioner who you're comfortable with. We always tell all of our clients the most important outcome we can have, you can have in your attorney-client relationship with us is you get healthy. You get back to your life. You move forward. You enjoy life. That's our goal. We'll never be able to get you enough money for your case that it will be worth losing your enjoyment of life. I think one of the main misconceptions that people have when they first contact us is, well, will our case be in trial? Will we have to go, you're a trial firm, which we are, but will we have to go to court? The fact of the matter is that most of the cases, the vast majority, somewhere on the order of 80% in our experience over the years, do resolve without a lawsuit. So we are able to marshal all the evidence using our staff to a great extent of paralegals that work with us, and we develop the case in a manner such that we can present it to the insurance industry in a way that they want to pay the settlement rather than have you file a lawsuit. And so that's one of our goals, is a very expeditious and prompt resolution of the claim as soon as our client has reached what the doctors call maximum medical improvement, that level where your health has improved to a point where it's expected it'll maintain the same plateau going forward. The decision about whether to go to trial has great ramifications in terms of your potential to recover. It is true that if you go to trial, particularly in our experience, if we go to trial in one of our cases, the results are very volatile. We have verdicts that are quite high for injuries that some people, frankly, might not consider that significant. And we have had cases, and I don't know any trial lawyer who's tried a case who never lost one, but we've had some cases where people, very deserving families, did not recover what they should have received because of various aspects of how the case ended up in front of the jury. So there are extreme benefits to settling if it can be done reasonably. One of the issues is, what's the fair value of my claim? And if you do not hire an experienced personal injury law firm, you will not have that information. And that is one of the things we can provide, we definitely provide, is a fair evaluation of the claim. We have the benefit in our firm of both of us having worked in the insurance industry for a number of years before we started our own practice. And we've now had our own practice in excess of 11 years, so we know what the insurance industry is paying for various injuries in the metro Orlando area. In terms of the decision that whether or not your case should go to trial or should be settled out of court, we always prepare each and every one of our cases for the perception of the insurance industry that we are happy to try the case. We embrace the opportunity to try the case. We like our clients, we believe in them, we're supportive of our doctors that are treating these nice clients, and we will take the case to trial, and we have done that for a number of years. And so my thinking is that if we can get a fair offer, that's usually going to be the best outcome for the client. But in terms of, are we prepared to try the case? Do we recommend that cases be tried? We recommend it every day. Just a question of what the individual case requires. But to have a blanket policy, as a law firm, we're going to file every single case in court, that has ramifications too. There are contracts of representation that increase the compensation to the attorney if the lawsuit is filed or at various stages of the lawsuit. So I would urge caution with any individual seeking counsel for a personal injury matter to be sure to read the contract and discuss it with the attorney, because there are significant differences. The purpose of really evaluating a claim fairly, instead of shooting for the highest number possible, is that we are trying to do what's in the best interest of our clients, which is an expeditious, prompt, and fair compensation. And so rather than take a chance, frankly, on the volatility of the jury verdict, and frankly, in these times of the delay that's going to occur as a result of simply requesting a trial date. Trials now occurring 18 months, 2 years after we file the lawsuit. So trying to get to a resolution with the insurance industry by a settlement will most likely be the best financial outcome for the client. To me, the most important fact that some people don't know about personal injury lawsuits is that it is your only opportunity to recover for what has happened to you that you were not at fault in creating. And so you do want to retain counsel that is experienced, that can direct you and guide you to the best outcome financially. And I think the tendency is for people to think, well, I'll be fine, life will go on, I don't really need someone that's prepared and anxious to represent me and file a lawsuit if necessary and go to trial if necessary. That's going to be more than necessary for me. I don't really need to even talk with an attorney of that type. I can just settle this on my own, or I can resolve it very easily So again, if you've been involved in a motor vehicle accident, or a friend or a family member has been involved, and you're not sure about what your rights are, and you're also not sure about whether your injuries warrant retaining a personal injury law firm, please give Beers and Gordon a phone call, 407-862-1825. All telephone conferences and personal conferences at the office are free of charge.